Welcome. The topic for this presentation is an unreported District Court decision of His Honour Judge McGill in 2016 in the matter of Wright and Wright, in which I represented the applicants. Although the case I will be discussing was decided in 2016, the principles it addressed remain very relevant today. Note that the case I will be discussing is completely different from the reported case of the same name, Wright and Wright, 2016 QDC 74. The case I will be referring to was matter number 1242 of 2015 in the District Court of Brisbane, with decisions by Judge McGill on the 19th of November 2015, the 25th of October 2016, and the 2nd of December 2016. There was no written judgment for the interlocutory hearing on the 19th of November 2015, but there were written reasons for the substantive hearing and the costs decision. You can download copies of those two decisions from my website at lawview.com.au, and I recommend that you do download those documents and have them available to look at throughout the course of this presentation. I don't know why those decisions haven't been published on the website of the Supreme Court Library. I've drawn this to the attention of the library and have suggested that these decisions ought to be published on that website, particularly because of Judge McGill's scholarly analysis of the law regarding co-ownership of personalty and the interplay between constructive trusts and family provision applications. Now, let's look at the facts of the case. The deceased, Stanley Ernest Wright, died on the 14th of July 2014 without a will. He was survived by his wife, the respondent, and by his son and daughter, who applied for further provision out of the estate. The respondent had other children who, as stepchildren of the deceased, had standing to apply for further provision from the estate, but they did not so apply. At paragraph 1 of the substantive decision, Judge McGill noted that no grant of representation had been made, and he directed that the application be heard and determined, although a grant had not been made. I'll come back to the issue of the grant shortly. In response to the applicant's application for further provision from the estate, the respondent applied for a declaration of a constructive trust in her favour over the major asset of the estate, which was the house that was the shared residence of the respondent and the deceased. The respondent also applied for the proceeding to be stayed on the grounds that no administrator had been appointed to the estate. The respondent made that application for a stay, even though she was the person with the highest entitlement to apply for letters of administration, and she had not applied for that grant, nor did she intend to apply for that grant. At paragraph 3 of the substantive judgment, His Honour referred to the interlocutory applications made by the respondent, which were heard before His Honour on the 19th of November 2015. Prior to that preliminary hearing, the applicants suggested that the respondent's application for a declaration of a constructive trust over the house should be heard with the trial of the substantive proceeding for family provision. The respondent accepted that proposal, and consent orders were made to that effect. That left the respondent's application for an order for a stay of the proceeding until an administrator had been appointed to the estate. The fundamental basis of that application was that the personal representative of an estate is, it was argued, the appropriate respondent to a family provision application. In response to that argument, the applicant's position was that 1. Where there is no pressing need for the appointment of an administrator, it is often logical to await the outcome of a family provision application before determining to whom letters of administration on intestacy should be granted. 2. The cost of an independent administrator would impose an unnecessary burden on the modest estate, particularly where the only role of the administrator would be to act as an observer and abide the order of the court. 3. Rule 26, Sub-Rule 2 of the UCPR says that an application must name as respondents all persons directly affected by the relief sought in the application. As the respondent and the applicants were the only persons who would be affected by the relief sought in the applications, they were respectively the proper contradictors and the only necessary parties to the applications. Judge McGill agreed and said that, as the only persons who had any interest in either application were the existing parties to the proceeding, and the only practical effect of having an independent administrator to conduct the litigation would be to increase the cost of the litigation, given the modest size of the estate, it was better to make do with the existing parties. That brings us to the substantive hearing. Fundamentally, this case was an application for further provision from the estate by the two applicants. The respondent's strategy was to endeavour to exclude as much property as possible from the estate. She did this by two methods. Firstly, the respondent claimed that certain chattels were acquired by the respondent and the deceased as joint tenants. Secondly, the respondent claimed a constructive trust in her favour over the house, of which the deceased was the sole registered owner. Those issues needed to be determined before the claims for further provision. In relation to the first of those two issues, Judge McGill provided a detailed analysis of the law relating to co-ownership of chattels and choses in action. It has been my experience that in the administration of estates, the approach most often taken is that chattels owned by a husband and wife are treated as passing by survivorship without any real analysis of whether that is the correct position at law or in equity. Often the value of the chattels is not worth quibbling over, but that is not always the case. This is a crucial issue for succession lawyers because, of course, property that was owned as joint tenants does not form part of the deceased's estate and is therefore not part of the property pool that is available to satisfy a claim for further provision from an estate. In this case, although the ownership of the joint bank account of the deceased and the respondent was not disputed, in that it became the property of the respondent by survivorship on the death of the deceased, His Honour made useful comments about the nature of co-ownership of bank accounts and of choses in action generally. At paragraph 5, His Honour said, "There is no doubt that property owned by husband and wife can be owned either as joint tenants or as tenants in common. At common law, the presumption was that property acquired by two or more people was acquired as joint tenants, so that it was necessary to specify expressly that the property was acquired as tenants in common to achieve that legal result. His Honour noted that that rule was overturned by Section 35 of the Property Law Act 1974. Subsection 1 of Section 35 says, "A disposition of the beneficial interest in any property, whether with or without the legal interest, two or more persons together, beneficially, shall be construed as made to or for them as tenants in common, and not as joint tenants." His Honour then set out a detailed analysis, referring first to the report of the Queensland Law Reform Commission that led to the enactment of the Property Law Act, and a review of the same topic by the Western Australian Law Reform Commission. His Honour also noted that equity generally preferred tenancy in common over joint tenancy, but that there was no general presumption either way in equity. His Honour noted that, at common law, co-ownership of a chose in action is possible only as joint tenants, but that the position in equity may be different depending on the circumstances. I would add that a joint bank account is also subject to the terms of the contractual arrangement between the bank and the depositors, which is usually to the effect that any depositor may withdraw the entire balance unless there is a specific arrangement requiring multiple signatures or authorisations for a withdrawal. At paragraph 24, His Honour referred to the situation where chattels are purchased by two parties, usually evidenced by a contract in the names of both parties as purchasers. His Honour said that, in that situation, Section 35 of the Property Law Act comes into play so that the legal title to the property will be held by the purchasers as tenants in common, unless there is some express provision to the contrary. And in those circumstances, the beneficial interest in the property will also be held by them as tenants in common, unless they specifically agree to hold it as joint tenants, or unless there are circumstances which would give rise to a resulting or constructive trust. At paragraph 25, His Honour said, "I do not consider that the mere fact that the chattels were purchased by a husband and wife in the name of both of them, and that they were chattels which would be used by them both, and the expectation was that they would be used by them both in the course of the marriage, is sufficient to displace the operation of Section 35. I consider that there would need to be clear evidence to show an agreement or common intention that the equitable interest in the property be held by the parties jointly, in order to displace the presumption in favour of a beneficial tenancy in common." His Honour continued in paragraph 26. "In the present case, I am not persuaded that that was shown in respect of any of the particular chattels which were owned by both the respondent and the deceased at the time of his death, with the result that a beneficial half-interest in each of those chattels remains in the estate." His Honour went on to discuss the Ford F-250 motor vehicle owned by the deceased, as the respondent had submitted that she was entitled to the entire beneficial interest in that vehicle because it had been purchased with her money. His Honour said that, even though the F-250 may have been purchased with the respondent's money, it was purchased in the names of both the respondent and the deceased, so that prima facie Section 35 applied, and the beneficial interest was held by both of them as tenants in common. His Honour said that the respondent's evidence about the circumstances of the purchase did not displace that presumption, nor support a conclusion of a resulting trust in her favour. A footnote in the judgment says that the respondent said there was no discussion about survivorship when the F-250 was purchased. Indeed, that would normally be the case when a husband and wife purchase chattels together. They are unlikely to discuss whether they are purchasing the chattels as joint tenants or as tenants in common. But in the absence of any such discussion, Section 35 will apply, so that chattels held in the names of a husband and wife will be owned by them, both legally and beneficially, as tenants in common. At paragraph 28 of the judgment, His Honour noted that the respondent claimed reimbursement from the estate for rates and water bills she had paid in relation to the deceased's house. The respondent was still residing in the house, along with her daughter, who was also not paying rent to the estate. His Honour rejected the respondent's claim for reimbursement of rates and water bills. Having thus determined the extent of the assets and liabilities of the estate, the total value of the estate was calculated to be a modest $376,412, subject to the respondent's claim for a constructive trust. Which brings us to the respondent's claim of a constructive trust. As with property owned as joint tenants, property that is impressed with a constructive trust does not form part of the deceased's estate and is therefore not part of the property pool that is available to satisfy a claim for further provision from an estate. The respondent claimed a constructive trust over the house arising from her contributions to that property, which were said to be a payment to discharge the mortgage and paying for the construction of a deck. The applicants acknowledged that the respondent was entitled to a constructive trust arising from those contributions, but the onus was on the respondent to prove the value of that encumbrance. The applicants argued that the value of the trust was to be determined by the amount by which the value of the house was improved by the construction of the deck, not by the bare amount that was paid for the construction of the deck. The respondent eventually conceded that that was the correct approach, that is, that the value of the respondent's contribution by way of construction of the deck was not to be assessed by the amount paid, but rather by the amount by which the value of the house was increased by construction of the deck. After analysing the evidence, which His Honour said was difficult to follow and not always consistent, His Honour concluded that the respondent was entitled to a constructive trust arising from her contributions in the amount of $94,900. That then reduced the value of the estate to $281,512. Therefore, the intestacy provision that each of the parties would have received, but for the applications for further provision and before any consideration of costs orders, were for the respondent $193,837, and for the applicants, $43,837 each. His Honour then went on to consider the merits of the applicant's claims for further provision from the estate. One of the significant factors taken into account was that the respondent had already received 100% of the deceased's superannuation, amounting to $415,000, which was significantly more than the entire value of the estate. Other relevant factors were that the male applicant was 41 years of age, single, in a modest financial position, and with some health problems, and the female applicant was 38 years of age, single, unemployed, and with significant health problems. The respondent also had significant health problems. None of the parties adduced medical evidence in relation to their health issues, but nor were any of the claimed medical conditions disputed. After analysing the relevant factors, His Honour concluded that the female applicant showed clear need and had other moral claims on the bounty of the deceased, and the intestacy provision made for her was, quote, quite inadequate, unquote. The claim of the male applicant was said to be not as strong, but His Honour also concluded that the intestacy provision was not adequate for him either. In the end result, each of the applicants were awarded further provision in lieu of the intestacy provision in the amount of $70,000 for the male applicant and $150,000 for the female applicant. As a matter of practicality, it was ordered that those payments be made from the proceeds of sale of the deceased's house. But as a matter of practicality, of course, the respondent could choose to pay out the applicants from her own resources instead of selling the house, but that was entirely up to the respondent. At the end of the decision, His Honour advised submissions as to costs, but indicated that he was inclined to let the costs lie where they fall, that is, with each party bearing their own costs. But that inclination was not reflected in the ultimate decision on costs after written submissions were made. This was an early decision on the application of Rule 700A of the UCPR. At paragraph 8 of the costs decision, His Honour said, Rule 700A is relatively new, and I am not aware of any authorities on how it ought to be applied, and to what extent it modifies the old approaches to costs in applications for provision under Section 41. Clearly, however, it was intended to modify those approaches, and the content of the rule suggests that greater emphasis should be placed on the responsibility of a particular party for the fact that the matter was not resolved, or at least conducted more efficiently, than has been the case in the past. It was noted that the respondent had succeeded on her claim for a constructive trust, and that the applicants had not disputed that the respondent was entitled to a constructive trust, but only that the extent of that trust was in dispute. And it was noted that the applicants had both succeeded in their claims for further provision from the estate. Judge McGill referred to offers that had been made by the applicants, effectively to settle for $175,000, and a subsequent joint offer to settle for $150,000. It was noted that the applicants had done significantly better than even the higher of those offers. His Honour said that overall, the applicants were adopting a reasonable approach, and it was the respondent who was behaving unreasonably, both in her reaction to offers of settlement made and in the offer of settlement that she made. His Honour noted that there was some force in the argument that the costs should be assessed, at least in part, on the indemnity basis, but that there were considerations to the contrary, namely the unpredictability of the outcome and likely costs orders, and the discretionary nature of the relief sought. On balance, His Honour declined to make an order for indemnity costs and ordered the respondent to pay the applicant's costs on the standard basis. This highlights an important consideration in family provision claims in small estates, namely that applicants need to be willing to make very sensible offers, and if they do, they may consider themselves in a strong position to obtain favourable costs orders, even contrary to a judge's first inclination. So, in summary, this case addressed the following propositions. 1. That a family provision application by the adult children of the deceased can overcome the priority of the intestacy provision for the deceased's spouse. 2. That it is not necessary to have any person representing the estate as personal representative in a family provision application, as long as the parties are all of the persons whose interests may be affected by the outcome of the proceeding. 3. That a spouse may have a good claim for a constructive trust over property that is held in the sole name of the deceased. 4. That chattels co-owned by a husband and wife are presumed to be beneficially owned as tenants in common, and that presumption will continue to apply unless there is sufficient evidence to rebut it. 5. That an applicant for further provision from a small estate may take courage to proceed to trial if they have made a very reasonable offer of settlement, and likewise a respondent in a small estate must act reasonably or face the prospect of a costs order. I hope you have enjoyed this presentation and have learned a little something from it. Feel free to contact me if you wish to discuss any succession law matters.